Thank you, Presiding Officer. I am delighted to open the debate on the general principles of the Legal Services Scotland Bill. At the heart of this bill is the removal of the current restrictions on how solicitors can organise their businesses. It will allow solicitors to form partnerships with non-solicitors, to create businesses offering a range of legal and non-legal services, and to seek investment from outside the profession. It introduces a robust regulatory regime to govern these entities. However, the bill is enabling rather than prescriptive, so traditional business models will remain an option. No solicitor's practice in Scotland is forced to choose ABS. This bill will, I think, create many opportunities for business in Scotland, Presiding Officer. Let me spell out some of these opportunities. Firstly, it will open up opportunities for the larger legal firms. This is excellent news. We are all for it. The reality is that the partnership model restricts their options to grow, restricts their options to compete in the international business market. The multidisciplinary practice is an attractive model for such firms bringing a range of services under one umbrella. I believe it will encourage firms to remain Scottish and not to choose to be regulated in England. These provisions will also allow such firms to bring their office managers, accountants and paralegals into the partnership. They will have the opportunity to seek to join with other professionals so that they might continue to be viable in challenging economic conditions. The Law Society, through their estimable president, Ian Smart, gave an excellent example to the committee in December of the opportunities which this bill might provide, such as a business that offered a land acquisition service that scouted out land for clients. The business would have a land agent, a surveyor and a solicitor to deliver a service that involved identifying and valuing the ground, negotiating the price and acquiring the ground. That would all be done by one partnership of different professionals. The bill, Presiding Officer, contrary to what has been claimed by some, also offers possibilities to smaller and medium-sized solicitor firms to bring others into the partnership, to join with others so that they might continue to be viable and competitive in challenging economic conditions. This bill has also been supported by the Business Experts and Law Forum, who explicitly endorsed the model of ABS as good for business. In short, and I have given just a few examples, members will no doubt come up with their own. This bill will create the environment where we will see economic growth, we will see opportunities, we will see more jobs created, we will see more business done in Scotland, we will see more business done by legal firms in Scotland, and we will see more business done by Scottish legal firms further Scotland. This bill will be a particular benefit, I believe, Presiding Officer, in years to come, in the medium and long term, certainly a huge benefit to young Scots, to young lawyers, as they will see more work created, more business for them to do, and therefore more opportunities for jobs. I hope that everyone will join with me in endorsing this view of the bill as one which is an outstanding opportunity for the profession in Scotland to avail themselves of the new business frameworks that will be permitted to grow their businesses and to create jobs and opportunities for fellow Scots. I certainly will.
Thank you very much indeed. I think the Minister, however, will agree with me that his enthusiasm for the bill is not exactly shared by a significant part of the legal profession, particularly in smaller firms. I wonder what assurance he can give to them that, in fact, the bill will not be damaging to their particular interests and to the future of traditional legal firms in Scotland.
Well, I am coming on to address that specifically, but perhaps I might just say that experience abroad and in other jurisdictions, whilst not exactly identical, is extremely encouraging. In Australia, similar frameworks were created 10 years ago. At the time, there were predictions of doom. In particular, there were predictions that small businesses would go to the wall. We have had evidence from Australia, albeit not an absolutely thorough analysis of exactly what is happening there right now, but we have had authoritative statements from Australia that nothing can be further from the truth, that the experience and the lessons from experience there have shown that small firms have benefited from the opportunities that were created 10 years ago, and the doomsayers were proved to be wrong. But I will come back and address that further later on. Presiding Officer, in this bill, we will not set up a super regulator quango in Scotland equivalent to the Legal Services Board in England and Wales. By not doing so, we will save tens of millions of pounds. Despite the understandable fears about the proposals, I have no doubt this is a necessary change which will benefit the legal profession, but also the consumer and the wider Scottish economy. I welcome the Justice Committee's comments in its Stage 1 report and its support for the general principles of the bill. The committee suggested a number of points for further consideration, the vast majority of which I accept, and in my formal response to the report, I have already set out our plans to address these. Whilst I am pleased that there has been much debate in the legal profession about the proposals in recent months, many of the arguments put forward by those opposing the bill have been misinformed, exaggerated or downright misleading. Legitimate and reasonable concerns have been raised by opponents of the bill, many of whom, Presiding Officer, I have met and with whom useful discussions have taken place. However, the rather lurid accusations of a few risk turning a constructive discussion about the future of the legal profession in Scotland into an unedifying stramash. I would like to take a few minutes to refute some of the more outlandish claims which have been made about the bill. Firstly, the bill will not destroy the independence of the legal profession in Scotland or endanger Scots law. We, all of us, across all parties in this chamber, support a strong and independent Scottish legal profession. This is set out in the regulatory objectives in Section 1 of this bill, to which Scottish ministers are bound. Secondly, the bill will not give the Scottish Government control of the Law Society. We have quite enough to do. Provisions to give Scottish ministers the powers in relation to lay members of the Law Society Council were always seen as a last resort. They would never have allowed the Scottish Government to control who was a member of the Council. After further discussions with the Law Society, I have decided to introduce an amendment to delete those regulation-making powers at Stage 2 because they are not necessary given the assurances that we have received from the Law Society. Thirdly, the bill will not allow criminals to take over law firms. The fit-to-own tests in the bill are robust. Regulators will have wide powers to reject those whose probity and character suggest that they are unfit to own a firm providing legal services. And this includes, Presiding Officer, associates of applicants. This is an extremely strong system of safeguards, and we are not available of any comparable legislation in this country which offers more protection. Furthermore, following constructive suggestions from the Justice Committee, we are preparing additional sanctions which can be used to disqualify individual investors from the new licence providers. Other suggestions have been made by some in possession of overdeveloped powers of imagination that the bill will give the Scottish Government control over the legal profession itself, that the recent referendum on ABS was rigged by the Law Society, and that drug barons will be able to use licensed providers to launder money. I could go on. Again, whilst I appreciate the depth of feeling that this debate has provoked, these contributions, I would suggest, have been unhelpful. The profession have now voted twice in favour of ABS, albeit by a narrow margin in its referendum of the whole of the solicitors' branch of the profession in April, and once against. Whilst I am sure that they will continue to discuss this issue and we will remain open to discussing any concerns, I think we also have to move forward. This bill was designed primarily to open up the legal services market in Scotland. Whilst there are certainly significant opportunities for the legal profession, we should not overlook the benefits to the consumer and indeed the wider economy. Consumer groups have come under some criticism for being unable to give definitive proof that there will be consumer benefits from ABS. However, this is understandably hard to do, given the entities in question do not yet exist and experience in other jurisdictions is relatively limited. But what they can do... Certainly.
James Kelly.
Thank the Minister for taking the intervention. He's discussing benefits of the bill, and earlier in his speech he said that the introduction of it would save tens of millions of pounds. In relation to that, how does he feel about the view of ICAS that the introduction of the bill would be costly to create and operate? And does he feel that the financial memorandum is fit for purpose when the costs are less than £100,000 in order to regulate these changes?
Minister.
My reference to saving tens of millions of pounds is based on the fact that the cost of the Legal Services Board in England, as I understand it, is circa £4 to £5 million per annum. Now, in Scotland,